Mitigating circumstances, Article 13 of the RPC, Part 5. Children in conflict with the law shall undergo diversion programs without undergoing court proceedings subject to the following conditions. A. Where the imposable penalty for the crime committed is not more than 6 years imprisonment. The Law Enforcement Office or Punong Barangay with the assistance of the local social welfare and development officer or other members of the local councils for the protection of children, LCPC. Established in all levels of local government pursuant to Republic Act No. 9344, shall conduct mediation, family conferencing and conciliation and, where appropriate, adopt indigenous modes of conflict resolution in accordance with the best interest of the child with a view to accomplishing the objectives of restorative justice and the formulation of a diversion program. The child and his/her family shall be present in these activities. B. In victimless crimes where the imposable penalty is not more than 6 years of imprisonment, the local social welfare and development officer shall meet with the child and his/her parents or guardians for the development of the appropriate diversion and rehabilitation program. In coordination with the Barangay Council for the Protection of Children, BCPC, created pursuant to Republic Act No. 9344. C. Where the imposable penalty for the crime committed exceeds 6 years imprisonment, diversion measures may be resorted to only by the court. See Section 23, Republic Act No. 9344, Conferencing, Mediation and Conciliation. A child in conflict with the law may undergo conferencing, mediation or conciliation outside the criminal justice system or prior to his entry into said system. A contract of diversion may be entered into during such conferencing, mediation or conciliation proceedings. Section 25, Republic Act No. 9344. Contract of diversion. If during the conferencing, mediation or conciliation, the child voluntarily admits the commission of the act, a diversion program shall be developed when appropriate and desirable as determined under Section 30. Such admission shall not be used against the child in any subsequent judicial, quasi-judicial or administrative proceedings. The diversion program shall be effective and binding if accepted by the parties concerned. The acceptance shall be in writing and signed by the parties concerned and the appropriate authorities. The local social welfare and development officer shall supervise the implementation of the diversion program. The diversion proceedings shall be completed within 45 days. The period of prescription of the offense shall be suspended until the completion of the diversion proceedings but not to exceed 45 days. The child shall present himself/herself to the competent authorities that imposed the diversion program at least once a month for reporting and evaluation of the effectiveness of the program. Failure to comply with the terms and conditions of the contract of diversion, as certified by the local social welfare and development officer, shall give the offended party the option to institute the appropriate legal action. The period of prescription of the offense shall be suspended during the effectivity of the diversion program, but not exceeding a period of 2 years. Section 26, Republic Act No. 9344. Where diversion may be conducted. Diversion may be conducted at the Punong Barangay. The police investigation or the inquest or preliminary investigation stage and at all levels and phases of the proceedings including judicial level. Section 24, Republic Act No. 9344. Duty of the Punong Barangay or the law enforcement officer when there is no diversion. If the offense does not fall under the category where the imposable penalty for the crime committed is not more than 6 years of imprisonment, or in cases of victimless crimes where the imposable penalty is also not more than 6 years imprisonment, or if the child, his/her parents or guardians does not consent to a diversion, the Punong Barangay handling the case shall, within 3 days from determination of the absence of jurisdiction over the case or termination of the diversion proceeding as the case may be, forward the records of the case to the law enforcement officer, prosecutor, or the appropriate court, as the case may be. See Section 27, Republic Act No. 9344. In case a law enforcement officer is the one handling the case, within same period, the law enforcement officer shall forward the records of the case to the prosecutor or judge concerned for the conduct of inquest and/or preliminary investigation. The document transmitting said records shall display the word child in bold letters. Section 28, Republic Act No. 9344. Determination of age of child in conflict with the law. The child in conflict with the law shall enjoy the presumption of minority. He/she shall enjoy all the rights of a child in conflict with the law until he/she is proven to be 18 years old or older. The age of a child may be determined from the child's birth certificate, baptismal certificate, or any other pertinent documents. In the absence of these documents, age may be based on information from the child himself/herself, testimonies of other persons, the physical appearance of the child and other relevant evidence. In case of doubt as to the age of the child, it shall be resolved in his/her favor. Any person contesting the age of the child in conflict with the law prior to the filing of the information in any appropriate court may file a case in a summary proceeding for the determination of age before the family court, which shall decide the case within 24 hours from receipt of the appropriate pleadings of all interested parties. If a case has been filed against the child in conflict with the law and is pending in the appropriate court, the person shall file a motion to determine the age of the child in the same court where the case is pending. Pending hearing on the said motion, proceedings on the main case shall be suspended. In all proceedings, law enforcement officers, prosecutors, judges, and other government officials concerned shall exert all efforts at determining the age of the child in conflict with the law. Section 7, Republic Act No. 9344. That the offender is over 70 years of age is only a generic mitigating circumstance. While paragraph 2 of Article 13 covers offenders under 18 years of age and those over 70 years, Article 68, providing for privileged mitigating circumstances, does not include the case of offenders over 70 years old. Prior to the enactment of Republic Act No. 9346 prohibiting the imposition of the death penalty, there were 2 cases where the fact that the offender is over 70 years of age had the effect of a privilege mitigating circumstance, namely: 1. When he committed an offense punishable by death, that penalty shall not be imposed, Article 47, Paragraph 1.